Good morning, ladies and gentlemen, friends, colleagues, comrades, brothers and sisters, welcome. And welcome to those that are joining us online. I understand we are live streaming the event. We will make a start. My name is Mukelani Deba. I am responsible for education and communications within the Information Regulator, and I will be managing the program today, assisted by Ms. Nomzamo Zondi, who is our Director of Communications. You see her walking around right at the back there. Thank you for coming out today to join us for this media briefing. The media is an important stakeholder for the Information Regulator, but we don't get enough opportunity to engage with you as our important stakeholder group. We would like to see many more of these opportunities where we present ourselves to you, we explain the work that we do, we speak about some of the key issues that we are encountering in the execution of our mandate as the Information Regulator. And we share with you things that keep us awake at night. This is what this session today is intended to achieve. It's going to be a very brief session today. What we will do is we will have a presentation of the statement by the chairperson of the Information Regulator, Advocate PAIA. Then we will open it up to questions from you all. Advocate Kakula will be assisted by members of the Information Regulator and executives of the Information Regulator who are in the room today. So without further ado, let me introduce you to who will be leading the discussions for the session. Firstly, we have on my left Advocate Colin Weapon, who is a full-time member of the Information Regulator, and he is the designated member for POPIA. So we have a member that is specifically taking care of all issues that relate to POPIA, and that is Advocate Weapon. Sitting next to Advocate Weapon is Advocate Lebogang Nzama, who is a full-time member as well, and she is the designated member for PAIA, the Promotion of Access to Information Act. Sitting next to Advocate Stronzama is Advocate Pensitla Kula, who is the Information Regulator Chairperson. If South Africans know anything about the Information Regulator, it's two things. It's Advocate Pensitla Kula and POPIA. So I don't know whether there's a band name that can be used there, Pensitla Kula and POPIA. I know you come from a musical family, Advocate Lakula. Think about it as your retirement plan, setting up that band. Then we have Mr. Mfana Kwala, who is a part-time member of the regulator. He chairs the Legal Services Policy and Research Committee of the Information Regulator. We have a member who is not yet joined. She's on her way, Ms. Alison T, who is a part-time member, and she heads the Education and Communication Committee of the Information Regulator. And we do have, as I said to the audience, executives from the Information Regulator. We have Ms. Shanti Reddy, who is the acting, acting executive for POPIA. We have Mr. Advocate Sebona UTD, who is the head of legal services. And we have Ms. Griswa Ramuzangwana, who is our Chief Information Officer. Chairperson, without further ado, I think we should begin the briefing. Over to you, Chair.
Good morning, everyone. Abshay. Good morning. Good morning. Abshay. It's not too enthusiastic. Program Director, all media present, my colleagues, members of the Information Regulator, our CEO in absentia, Mr. Musala Nyana Musala, who couldn't be with us today for personal reasons. all executives, and good morning to you and to everyone who is joining us virtually. I greet you today during the month when we commemorated the Youth Month, and we remember the youth of 1976 who fought the injustices of the then education system. We also celebrate and commemorate Pride Month, during which we recognize years of struggle for fundamental human rights and the ongoing quest for equal justice under the law for the lesbian, gay, bisexual, transgender, queer, intersex, and asexual community, otherwise known as LGBTQIA community. The Information Regulator grounds itself firmly as an organization that is people-oriented, and as such is an ally in efforts for the realization of human rights for the vulnerable, marginalized, and disadvantaged communities. We have just returned from Mexico, and when you see me, you can see that I'm not, I may not be too coherent because I've just had a long journey. Just came yesterday. We have just returned from Mexico after participating in the 13th International Conference of Information Commissioners, known as ICIC, where we had robust engagements on the right of access to information and how the global efforts can advance this right and bring it to its full realization. The ICIC connects information commissioners, ombudsmen, and other bodies overseeing the implementation of access to information legislation. Its executive committee includes Albania, Kenya, the USA, Brazil, Chile, Bermuda, and South Africa. And we are also, as I've said, the active members of the executive committee of the ICIC. It was also at the 13th ICIC that the executive committee of the African Network of Information Commissioners, called ENIC, was elected, with South Africa as the chairperson of the network. Other members of the executive include Tunisia as the deputy chair, Kenya as treasurer, Ghana and Sierra Leone as additional members. As you may know, embedded in our mission statement is our aspiration to be a world-class organization. Being part of these global platforms allows us to position ourselves and South Africa as one of the leading countries in the law and practice regarding the protection of personal information and access to information. I wish to remind you that the regulator has a dual function. We ensure the protection of personal information as outlined in the Protection of Personal Information Act, known as POPIA, and we also ensure the effective access to information as outlined in the Promotion of Access to Information Act, known as PAIA. It is evident that POPIA has grabbed the public's attention, and rightfully so, because it is a new law. However, we encourage the public also to exercise their right of access to information held by the state or by private bodies, and should they be denied access, they must lodge a complaint with the regulator. In a couple of days, it will be a year since the enforcement powers of the regulator came into effect. This is a milestone for the regulator. These powers give the regulator the means to secure the rights of data subjects to whom the personal information relates and requesters of information. The regulator can conduct investigations on complaints if the personal information of data subjects has been violated and there has been interference due to unlawful processing of their personal information in terms of POPIA, or where the requesters have been unjustifiably denied access to information in terms of PAIA. The regulator has since July 2021 received and pre-investigated over 700 complaints from data subjects. Most complaints received relate to direct marketing, which is a grave concern and an indication that responsible parties are not complying with Section 69 of POPIA, which relates to direct marketing by means of unsolicited electronic communication, and Section 11 on consent, justification, and objection. The regulator is concerned that South Africans continue to be bombarded with unsolicited direct marketing messages that do not comply with Section 69. This section prohibits direct marketing by means of unsolicited electronic communication, including through automatic calling machines, fax machines, SMSs, or emails, unless the data subject has given their consent to the processing or is a customer of the responsible party. There is a debate whether a telephone call constitutes an electronic communication in terms of the definition of electronic communication in POPIA, which defines electronic communication as any text, voice, sound, or image message sent over an electronic communication network, which is stored in the network or in the recipient's terminal equipment until it is collected by the recipient. The regulator intends to draft a guidance note on the interpretation of Section 69 of POPIA and will engage relevant stakeholders in this regard. However, Section 69 is clear insofar as the requirements for direct marketing through unsolicited electronic communication is concerned. Such processing is prohibited unless, one, the data subject has given their consent to such processing or is a customer of the responsible party. We have to be alive to the definition of consent if we have to protect our rights. It is defined in POPIA as voluntary, specific, and expression of will for which permission is given for processing of personal information. This means that requesting a data subject to simply opt out does not constitute consent within the definition of consent in POPIA. 2, the data subject must be contacted only once for the purpose of obtaining their consent. The responsible party must obtain the contact details of the data subject lawfully for the purpose of contacting them to obtain consent. This means that a responsible party must have derived the contact details of the data subject from a public record, or a data subject must have made their contact details deliberately public. Purchasing contact details of data subjects from data brokers is unlawful. 3, a data subject who was previously contacted and withheld their consent cannot be conducted again. 4. Any communication for direct marketing must contain the identity of the sender or the person on whose behalf the communication has been sent, and an address or contact detail to which a data subject can send a request that the communication must stop. We are articulating these requirements, and as you sit here, maybe some of you have received SMSs for direct marketing. You can open your SMS, if you have it, check it against the requirements. If you get an SMS that simply says, Pansy, opt out, that's not in compliance, because compliance is spelled out in the law, and we have summarized it in the paragraph that I have just read. The regulator has received a notification from the National Credit Regulator regarding the report about entities engaging in the sale of personal information, such as consumers' names and surnames, identity numbers, contact numbers, credit scores, and consumer debt review statuses belonging to consumers. As the regulator, we are warning responsible parties that continue to trade in personal information that this is in violation of POPIA, and we will not tolerate it. We are sending an unequivocal message to players in the credit granting and direct marketing sectors of our economy that this must stop. We say to those that offer to sell these lists and to those that buy them, do not allow yourselves to be the first examples of the regulator's bite. As a result of the above, the regulator has commenced a systemic investigation into the allegation of the unlawful sale of personal information of data subjects. The regulator would like to thank the Chief Executive Officer of the NCR, Ms. Nomsa Mutsikari, for bringing this information to our attention. Ladies and gentlemen, we are experiencing an alarming rate of security compromises or data breaches, and we have recorded 330 reports from July last year. In instances where there is a security compromise or the regulator believes that certain processing does not comply with any of the conditions for lawful processing of personal information, the regulator has the power to conduct its own initiative assessment. The own initiative assessments that the regulator is conducting at the moment involve WhatsApp, TransUnion, and the Department of Justice and Constitutional Development. All these assessments are at an advanced stage. Due to the prevalence of security compromises, the regulator has decided to establish a dedicated security compromise unit, which will conduct extensive investigations or assessments into the security compromises suffered or experienced and issue reports with findings and recommendations. These reports are, in terms of Section 91(3) of POPIA, deemed to be enforcement notices, and failure to comply with an enforcement notice attracts sanctions. As alluded to earlier, the regulator has a dual mandate, and it has also been a year since we took over the regulatory functions on PAIA from the South African Human Rights Commission. The regulator has completed its targeted compliance assessment on 15 municipalities across the country, 8 metros and 7 district municipalities, The above-mentioned assessments focused on some of the PAIA compliance matters, including the following: whether municipalities have updated their PAIA manual and made it available in at least 3 official languages, as well as making such manual available on the website of the municipality and at the head office for inspection during office hours. The assessment focused on whether the municipal manager has designated or appointed a deputy information officer. Our assessment found that 100% of the municipalities assessed do not have a valid PAIA manual. We have also dealt with some, or we're dealing with some of the important PAIA complaints that we will be sharing with you. And one is in the music industry, or regards the music industry license fees and royalty payments. We know the issue of payments of royalties for people in the music industry and the entertainment industry in particular, in general, is a problem. The right of access to information is one of the most significant rights in our Constitution, in that one cannot exercise any right without information. The regulator has received a complaint from Hardwick Trading Pty Limited, alleging that its request for access to records relating to the payment of the license fees and copyright royalties was refused by RISA Audiovisual Licensing NPC, known as REV. REV is a collecting agency which collects license fees and copyright royalties and pays over these amounts to record labels and musicians. The regulator is conducting an investigation into this complaint, and due to the allegations of lack of transparency and good governance in the music industry, the regulator has decided to hold a public hearing on this matter. The public hearing will be held from the 2nd to the 4th of August 2022. The details of this hearing will be made available in due course. One of the most important complaints in which an investigation is at an advanced stage is a complaint that relates to the rights of the community of Bethelsdorp in the Eastern Cape. The complainant is the Bethelsdorp Claim Holder Trust, which is a trust formed by the community of Bethelsdorp against Mission Soulspan Pty Limited and Swartzkopf Sysout Pty Limited. In this complaint, the community of Bethelsdorp alleged that their request for access to records, that is the list of payments made to the board representing the interested community from 1984 to date, has been refused, and that they require the record for the purpose of exercising their rights, among others, to benefit from the revenue of salt pen as prescribed in the Bethelsdorp Settlement Act 34 of 1921. And there is another complaint that we have completed, and I am highlighting here the significant complaints that we have dealt with or are dealing with. This list by no means represent the total number of complaints that we have dealt with under PAIA. Since the Information Regulator started handling PAIA complaints, we have had cases that had positive outcomes. We regard it as a positive outcome because the case demonstrated the power of accessing information in order to protect, exercise, or access other rights. In this case, we resolved a complaint from night practice administrators who were the beneficiaries of a deceased policy holder's life cover policy. The life cover policy had been taken out with Momentum Life. After the passing of the policy holder, the complainant, being night practice administrators, lodged a claim on the life cover policy. The claim was initially rejected because it was alleged that the deceased policyholder had misrepresented and or did not disclose certain information. The life insurer argued that had the policyholder given full disclosure about themselves, the insurer would not have issued the life cover policy. Upon receipt of the rejected letter, the complainant submitted a PAIA request with the regulator, which request was rejected. I beg your pardon. Upon receipt of the rejected letter, the complainant submitted a PAIA request with the holder of the information, and the request was rejected on the following grounds. One, that the decision contains confidential medical records of the policyholder, that the complainant is not the policyholder nor the appointed executor of the deceased estate, that the complainant did not confirm the rights that it seeks to exercise or be protected. After the regulator's intervention, the complainant's life cover claim was settled by Momentum, and as a result, the complainant's right to benefit from the policy was protected. The regulator has recently tabled its strategic plan in Parliament, and we outline our priorities for this term. We seek to conduct robust educational and awareness programs to advance the public's understanding of POPIA and PAIA, with a particular focus on disadvantaged communities, to ensure better management of complaints processes and increase human resources capacity to serve the public efficiently. In conclusion, in the first 5 years of the regulator, have been the years dedicated to forming the institutional framework for the regulator. The next 5 years will be devoted to actively demonstrating that the regulator is a shield that protects, the torchbearer that promotes, and the hand that assists in protecting personal information and promoting access to information. I thank you, and we are available to take any question that anyone might have. Thank you for coming.
Thank you, Chairperson. Ladies and gentlemen, it's now the opportunity for you to ask questions based on the statement that has just been given by the Chairperson of the regulator. How we will do this is we'll take a round of, we'll start off with 3 questions, and we'll put the questions to the members for their response, and then we'll take another round. May I appeal that when you pose your question, please first indicate who you are and the media house that you are coming from. So let me hand it over to you. Let's take the first round, please. I will start with the gentleman at the back, and over to you, sir, and the middle table. Please, name and media company.
Rian Boomerans from Media Holdings, like other publications. My question is just, it's interesting that there's been 700 complaints already in terms of the direct marketing part of the Information Regulator's job, and I see it as Advocate Nicola mentioned, there's been pre-investigation. So my question is, when does the office... that's better, yes. When will your office start making rulings on these complaints? What is the timeline for that?
Thank you, Rian. The middle table, please.
Ms. Roy Mahlaka from the Daily Matric. I've got two questions for Ms. Tlakula. The first is, you've set up this unit, the security comprise unit, to deal with incidences of data breaches. Do you have enough funding from the government to fund this initiative? Because I understand the last time I spoke to you in 2020, you did complain that the Information Regulator doesn't receive enough funding or resources from the government. So do you have enough funds to get forensic or IT skills to boost this new security compromise unit? The second question is about, again, incidences of data breaches. Does it worry your office that we've seen some incidences of possible data breaches whereby companies, mainly banks, do not inform their clients within time or immediately after they detect potential security breaches? Does it worry that some companies sit on information about data breaches before informing their clients or even approaching you as the regulator to inform you about such incidences? Thanks.
Thank you, Ray. Over to you, sir.
Raymond from Network 24. Earlier this year, there was some confusion regarding the publication of the Matric results. My question is, what does the way look forward to publishing the Matric results on media platforms?
Thank you. That's the first round. Let's. Is that us? It's not us. Oh, the neighbors. Okay. Okay, no, that's fine. Let's take those four questions, please.
We're going to ask Advocate Strong to deal with the question regarding complaints, Advocate Weapon to deal with the question relating to security compromises. I will deal with the questions on Matric results.
Okay. Thank you very much, Chairperson. I'll respond to the Arena Holding question. Yes, indeed, we received a lot of complaints relating to direct marketing, which is a problem. And as the chairperson of the committee of the Complaints and Investigation Committee, we have noticed that the trend is that the responsible party will desist once the complaint has been lodged from sending that direct marketing to data subject A, but will continue to go to data subject B. And I think that's where the problem is. So I think before I can give you the timelines in our investigation, I think what we need to consider is, as a committee, to make an assessment on this responsible party in terms of how they deal with direct marketing, so that we remedy all the data subject, not a specific data subject, because individually they are resolved at a go as in we investigate. But if we deal with one company, let's deal with all the responsible party in that company and assess in terms of how they deal with direct marketing. So I think we'll be able to bridge the gap of direct marketing, but it is indeed a huge problem. Thank you.
Thank you so much. Concerning the question on security compromises, so the first aspect that I'd like to deal with is the issue of funding. So the issue of funding relating to the appointment of IT skills in particular, as well as skills that will be necessary to drive and resolve security compromises. So that is a very important question. So we are funded to the tune of about 100 million, that's our total budget. But we know that very complex technical cases require a lot of technical skills, and that would then, in some instances, have a huge impact on the budget. So more budget is always welcome, and as we are forming the security compromise unit, that's where the chairperson and members have focused on, in particular, acquiring the forensic skills that you refer to, as well as the ICT skills or the digital forensic skills, in order for us to ensure that those skills are optimized and utilized to investigate complex matters So that would be the response on your first part, or the first question. But then to the second part of your question, where the responsible parties fail to report security compromises or inform data subjects within reasonable time about the security compromise and measures that they should take to ensure that those data subjects are not further compromised. We would definitely, as the regulator, caution against such behavior because it's a violation or contravention of Section 22, 4 and 5. And that in particular places a responsibility on a responsible party or a company, whatever you want to call them, to ensure that data subjects are informed within reasonable time or timeously of the fact that the data breach occurred or a security compromise occurred and the measures that they should take to ensure that they are not further compromised or their personal information is not further compromised. So those are aspects that the regulator always focuses on. You will also notice that during the TransUnion data breach, the regulator had specific detailed interaction with TransUnion to ensure that data subjects are timeously informed, and the regulator also advised TransUnion on the platforms and measures that they should take when TransUnion interacts or inform their data subjects about the data breach that has occurred. Thank you.
Chairperson, if you don't feel like answering the question on the Matric results, Elijah is over there. He can answer that question. I'm joking.
What I can say about Elijah is that we share everything.
He's forgiven.
So, we've been quite, what can I say, accommodative on data subjects, and we have on responsible parties, and we have not exercised our powers thus far. And the only reason for that is that POPIA is new, and we have been patient with responsible parties, trying to take them along the interpretation of, and assisting them with the interpretation of POPIA. But that is coming to an end. I think we have done enough consultation. We then have to begin to exercise our powers. And with these security compromises that we are investigating, we will, at the end of that investigation, we will decide whether, appropriate action has to be taken or not. I think Mr. Gwala, brand new member of the regulator, responsible for legal policy and research, is going to answer the question on the Matric results.
Well, I will start by saying, like the chairperson of the regulator has correctly pointed out that we understand that POPIA is new and a lot of people are still familiarizing themselves with it. And hence we had this issue last year of Matric results because there are people who still believe that they can be business as usual, where you can just publish Matric results and there are no consequences for that. So the general rule is that the publication of Matric results is the processing of personal information. And for that to happen, you need the consent of the data subject. And in this context, because we're dealing with children, we need the consent of the guardians. And unless that is provided for, you can't publish this. And this is the information we presented when we had that engagement with the department, and that's why we actually wanted to join that court case. So that's the starting point. We can't tell the department what to do, but we did give some suggestions. For an example, when they were due to publish the results, we understood that the time was very short when they became aware that in fact they couldn't go ahead as they used to in the past. And we had said, unless the system can allow a data subject who does not want the Matric results to be published to opt out. And quite clearly with the challenges that the department had, they couldn't basically provide that assurance. Hence, they correctly decided that they are not going to publish the results now. But when you know the story, AfriForum joined the fray, and I think the department to an extent relented. But the bottom line is, we are saying publication of Matric results, even if you are using because the argument was they are using student numbers. I mean, the Act is very clear. Any information that you are using that can be associated with that result, and information that is not sufficiently identified to an extent that the person cannot relate it to the data subject, that information you seek consent if you want to publish it. It's as simple as that. So our advice is that the department, hopefully, they have solicited consent from the learners, they've solicited consent from the guardians of those learners who are underage to publish that information. If that is not the case, then they'll fall foul of it. That's the simple answer.
Thank you very much, Mr. Mhlanga. This is now free advice. You have a couple of months to publish those results. And it's easy. I mean, when students, for instance, if I were you, unfortunately I'm not you, but if I were you, what I would do is that when students register for Matric, and as they do that, I would have a form, a consent form to say, do you consent to the publication of your results, you or your guardian, and they tick. And once they've done it, this is electronic. And by that, by doing that, you would have solicited that consent. But you must have a privacy policy in the department. I hope you do. And what that privacy policy provides for processing of all sorts of types of information that you process, including Matric results. So this is kind of free advice that we are giving to them.
Which we don't often do.
Which we don't often do.
Because his friends and family will do so. We have an exception for Mr. Mhlanga. Thank you, Chair. Thank you, members. Let's open it up once more for another round. I will start with the lady at the back. Please say your name and your media company, and Mr. Minar, and the lady at the front table.
Good morning. My name is Cindy from ITWeb. In light of the data breaches, I'd like to find out, have any fines been administered, and if so, how much? My second question is for Advocate Tlakula. You've previously bemoaned the over-processing of personal information, particularly by security firms. So I'd like to find out if there's been complaints from data subjects around that, and what the regulator is doing in terms of raising awareness with the security firms around over-processing of personal information. Thank you.
Thank you. Isaac.
Thank you. Isaac Manar, I'm from the South African National Editors Forum and the Press Council. At SANEF, we very often receive complaints from journalists saying that POPIA is used to shield certain companies from disclosing information from them. I want to read you a recent complaint that we received from a consumer journalist. The journalist said, a few companies, a debt counseling firm Dotsure and the SA Home Loans, have recently refused to respond to my media queries about one of their clients unless said client signs a power of attorney citing POPIA. This is despite the fact that Section 7 states that it doesn't apply to journalists in the scope of their work. And never mind that the client emails clearly asked me to take up their case and approach a company on their behalf. I wonder if you can just clarify on the record how the journalism exemption works, and whether there's any way that you can assist journalists when they get confronted by companies who do not want to disclose information to journalists. Thank you.
Thank you, Isaac.
Good morning, everyone. I'm Chidi Sananindo from Great Match. So I actually have two questions, but I think the lady at the back actually covered some parts of my question, which was relating to like what are some of the recommendations that have been tabled, like just to deal with the violations of the POPIA Act. And the other question is like what are some of the challenges or limitations that you have noticed within our Act in relation to the global players, just surrounding the protection of personal information. Thank you.
Thank you. Let's hand it over to the members for the responses.
Advocate Leo, can you respond to the question regarding fines? Have we administered any fines? If not, why? And regarding surveillance security firms, I will respond to that, and Mr. Dimba can also assist because of the research that we did. Regarding the journalistic exemption, Mr. Can you deal with that? I will also try and deal with some of the challenges globally.
Thank you, Chair. I'll respond to the fines. We haven't, remember, POPIA gave us, we can levy fines up to the maximum of 10 million. But we haven't at this stage levied any fines because, like the Chair said, POPIA is still new. Most of the time we try to educate, but now we are in a stage where, like the Chair said, we will start doing, after investigations or assessment, we'll take that route. But we're trying to be patient to educate, to say, POPIA is now in operation, kindly make sure that you comply. But I mean, on some of the matters, we are now doing assessment on initiatives. So that will lead us to that route where we start now levying those fines. Thank you.
I think the whole issue of security firms falls under a very difficult, complex issue of surveillance. And it's not only, and the surveillance constitutes processing of personal information. And it's an issue which we started doing some research, basic research, which Mr. Dimba will share with us, and that research will assist us to determine how we move forward with surveillance. And we think we need a guidance note, because definitely there is over-processing of personal information by security companies. This morning, that over-processing happened at the gate. I tried, they asked, obviously they screen the disc of my car, and then they asked for my license. I said I don't have it, and they said ID. I said I changed my bag, so I don't have an ID, I don't have a license. So the man says, then I have to take your full names. So I gave him my full names. And then as if that was not enough, says, can you look at me, I have to take your picture. This now is ridiculous. But I was running late and I just got obliged. But I think that we have to address that, because it's a big problem. It's surveillance, private properties by private bodies, not only in terms of this kind of surveillance with a camera and everything at the entrance. We have surveillance in our streets with Vuma cameras all over the place, whether that complies with POPIA or not. There are debates that we lose our privacy in public spaces. I do not know about that. We still have to do our own research regarding that. And the surveillance also conducted by police in the course of an investigation of a crime. So that whole scene is is something that we are looking at and we're going to be issuing a guidance note on the do's and the don'ts. Mr. Timber, can you just share with participants just briefly the outcome of the research that
Thank you, Chair. No, I will do so, and Ms. Shelembe is also here to add. So we conducted a pilot study on the use of CCTV cameras in South Africa and its interface with POPIA. It was a fairly small study in the sense that the sample was quite small. We only looked at 3 municipalities and we had about 200 respondents. Really, it was just to test the waters, to get a sense of how this is working practically. We found that, firstly, the area of CCTV technology is not properly regulated. There is very little regulation of the sector. But when you overlay the issues of POPIA on that, then the problem becomes even worse, because we find that the service providers largely do not comply with the basics of POPIA compliance. When you look at the 8 conditions for lawful processing of personal information, you have things such as the data subjects need to be notified that there is processing of personal information. You walk past these cameras, when they take video, they are processing information about you, but there is no notification of the data subjects that there is that kind of processing happening. We have issues around what happens to the data once it has been collected. What does a deletion look like? When does the data get destroyed? There are no rules for that. So each service provider, they basically follow their own rules and their own systems. Maybe Ms. Shelembe could also add a few more from the study, a few more findings from the study. Just 2 that I haven't mentioned.
Thank you so much, Mr. Timber. Indeed, we did conduct a pilot study on the use of CCTVs in South Africa and how do they comply with POPIA in general. And what Mr. Timber have alluded to in terms of this generally a lack of compliance with POPIA in as far as the use of CCTVs is concerned in South Africa. Yes, we did find that, and currently we are undertaking a national representative study on the use of CCTVs in South Africa. We are indeed looking forward to coming up with conclusive findings that will be national representative of South Africa in general, and also be able to inform the development or initiate debates around the development of the code of practice or code of conduct around the use of CCTVs in South Africa, which will enable or ensure that we do indeed comply. The use of CCTVs in South Africa does indeed comply with POPIA, as we all know that CCTVs do indeed collect a lot of personal information or process a lot of personal information. So indeed they are expected to comply with POPIA and the 8 conditions for the processing of such personal information. But the findings that you have alluded to, Mr. Timber, those are the findings that we did find, and we are looking forward to finding more conclusive findings in our national representative study. Thank you.
Thank you, Ms. Shelembe. May I hand it back to Ms. Thiele on the question regarding Section 7 exemption for journalists?
Yes, thank you. The exemption applies to the journalist's own processing of personal information. It was one of the issues that came up in the drafting of the law. Journalists have large quantities of personal information of other people, and which is appropriate, it's necessary. It's what journalists need to do the job that they do, and that's one of the reasons why POPIA specifically excludes journalistic activity from the operation of the Act. One of the things we have, however, seen is people using POPIA to defend information from journalists, to reject the requests of journalists for information. Ironically, when the Access to Information Act was introduced, it too was used by record holders to refuse records. I think what we can learn from this is that no matter how you try, pieces of legislation will be used by people in defense of their secrets, and there's often good reason they have secrets. So what I would say is certainly what we are not seeing, and it's disappointing, is many journalists actually using the access. The regulator has those two mandates together for a very good reason. It's because they do play off against each other. There is a tension between the two. The regulator is well placed to deal with that tension because it has both mandates. And what I would certainly be interested in seeing is more use of the Access to Information Act, which is part of our mandate and which is something that can be used not just for a record, but categories of records, sets of databases. It's very broadly defined, and we have the capacity in place now to deal with those requests. And as you've seen, we're now moving into a public investigation on one of them. So I'm not sure if that covers quite the question you're asking, but I would suggest that the regulator's authority is it's not being tapped into enough in order to deal with these issues around people being concerned about releasing information because of privacy issues.
Thank you, Ms. Tilly. Chairperson, the challenge with global players, and maybe you can draw in something about WhatsApp or Meta.
Isaac shaking his head, so I'm not sure what do I agree.
Did you want to do a follow-up, Isaac?
Before, let me, as he's thinking about that, I'm not sure what is going on here.
There's a focus.
Frankly, I was about to fall over backwards.
Oh no. The power of Isaac's question.
Yes.
Really tipped you over.
So can you then just clarify? So if a member of the public approaches a journalist, like this example of a consumer journalist, because they're not coming right with the company, now they go to the journalist to deal on behalf of them. And they give the journalist consent to share information and deal on behalf of them. Can the company just say, sorry, because of POPIA, we cannot help you, that's it? Can you please put on record exactly what can be done?
Yes. So if I understand you correctly, the journalist is in that instance asking the holder of the information to give them the information, which relates to that individual. And the holder of the information is then saying that they refuse to process the information unless they have proof that the individual whose personal information it is has given the journalist consent to receive the information. I think the simple way around it is simply to say to the holder of the information that you have the consent of the person who's requesting the information. I mean, the same thing happens when you ask a record holder for a record in terms of PAIA, and the record holder will then often say, well, do you have the permission of the person whose actual information it is or who relates to in making the request? Once you have a record of that consent, then you can proceed, and I can't imagine being in a situation where you wouldn't get that, so you would presumably have that from the requester. I'm sure if anybody has more.
Well, I mean, I'm trying to wrap my head around your question, whether it's a POPIA question or it's a PAIA question.
I think it occurs under both sets, under both laws, which is effectively that people are trying to use the law in order not to release the information, and they're trying to argue that you as a journalist are not authorized to ask for the information. PAIA gives a very specific authorization section in the form, so it's very clear from that point of view. POPIA doesn't do that in the same way because it's not set up in the same way. But at that point, I think if you have the consent of the data subject, that should be more than sufficient, and shouldn't then result in any refusal. But as I say, POPIA is underused, and I think with good reason by journalists, because it's been so, it's had no enforcement body attached to it for 20 years. And I think we've all seen the history of deemed refusals with reason. What I'm concerned about from the regulator's point of view is that certainly in regard to the media is that we're not seeing the media using PAIA. And you know what they say, if today is the first of the month and you make a PAIA request and you are journalist 1 and the second journalist number 2 doesn't make a PAIA request, in 30 days you'll both be 30 days older, but the first journalist will have for sure either the record or the deemed refusal of the record, and you can come to the regulator. So you can pick, but I know which option I would pick, and I would be using PAIA almost as a second part to any inquiry for information, so that if 30 days later or subsequent to an answer to the record, and records should be answered as soon as reasonably possible, then you then have the option to approach the regulator.
I mean, having said that, personal information published for purely journalistic purposes is excluded from POPIA. That we have to know, and I think you might recall a case many years ago which related to the publication of health information of a public figure. If that case was to be heard today by the regulator, it would probably have a different outcome. It's health information is publication of personal information, but it is covered by the journalistic exclusion because that's publication in the public interest. And if a complaint was to be lodged against the journalist for publishing that information, what would then do as the regulator would then look at whether the journalist's consent, whether their publication is subscribed through a code of ethics that contains adequate protection for personal information. And if the code of ethics does, then if there is to be any complaint regarding the publication of medical records, that complaint will have to be dealt with by the press council. But if the journalist or the publication has not subscribed to the code of ethics for journalism, then the regulator would then investigate the complaint, because the public interest override also applies. So these are all sections that still have to be tested in reality. Challenges POPIA globally. There's a say, and I think it's true that with the regulators such as ours, technology is always ahead of regulation. It's a big problem. And we see that, especially in the tech companies, or, everything that they are introducing, the regulators are always trying to play catch-up because technology is ahead. But there is also another perception that the regulations stifles innovation. And I've heard that, and I don't believe that. We can innovate, nobody's prevented from innovating, as long as that innovation takes into consideration the privacy of individuals, that protects their data. That's all, and that's all that we ask for. And globally, I think that's what the challenge is. But does POPIA compare favorably with laws internationally? I think it does. It
compares quite favorably with the General Data Protection Regulation, which people put it out there as the, ultimate data protection law, but ours is better and is the only one that protects even personal information of juristic persons. No one else does it. So we've got things that we have to show up in POPIA that are even better than the GDPR, but it compares quite favorably.
Thank you so much, Chairperson. I'm going to be the bad guy, ladies and gentlemen, because we are drawing very close to the end of this very interesting session. Is there a final burning question? One last question that somebody needed to ask before we close it off. You have the opportunity, ma'am. Chair will take one last question, and there will be a response, and then perhaps some closing remarks from the Chairperson.
Good morning. My name is Masha Zali. I'm a freelance journalist. So in terms of the data breaches from global companies, have you been able to determine which countries usually breach data, whether it's South African data, personal or data from your banks and financial institutions, and how far does the POPIA extend in terms of holding those whoever might have breached data globally accountable? Thanks.
Thank you, Masha. Chairperson, and then we close it off.
Thank you so much, Chair, and thank you so much for the question. I think you would know about the Cambridge Data Analytica security compromise, which was actually an investigation on Facebook where huge volumes of data was compromised, and the investigation was then undertaken in the UK. So about 495,000 users, Facebook users of South Africa's data was actually compromised. And what then happened is that we then wrote to Facebook, and we were referred to the Ireland office, and then we were also advised that the investigation will then be undertaken in the UK. There was a report published, part 1 and 2, and that report actually refers to the measures that needs to be implemented, the gaps identified, and also how the data breach occurred. And what is interesting about that specific event is that Facebook is a multinational company, and a data breach that could occur on its system could affect users in various countries. And what is also very important is that there was no, if I can say, solution, or there was no remedy for the South African users, and that report had some shortcoming because it only focused on certain countries and some reprieve for those users. And there was also a huge fine issued, but that was then for the UK's purposes, but because of the fact that the data breach occurred in the UK, and the investigation also undertaken there. But coming back to various other countries and multinationals, we also see that not only with Facebook, but with a few other examples, that there's a continuous compromise of information. And what is also difficult in that respect is that South Africa becomes one of many countries whose users are affected, and there's no clear indication, and it might be an opportunity, Chairperson, that we raise this issue with the Global Privacy Association about how do we accommodate and how do we include various countries and ensure there is an outcome that will suit all the affected users across different countries. But we saw, and there's some learnings from the Cambridge Data Analytica data breaches as a key example, and most recent one as well. Thank you.
Chairperson.
Happy to close?
Yes, please.
Thank you very much. I think we have to have more of these conversations. POPIA in particular, it's a complex piece of legislation. Just to interpret and to apply, and everyone is battling with the interpretation of POPIA. We have been patient enough, as I said, trying to take our stakeholders along and assisting. But we have now come to a point where we have to exercise our powers. We are not, we are alive to the fact that we will be acting against big players, and that they will fight, and they have the money to fight, and they will take us to court. But that is a challenge that we are geared up for. I mean, the WhatsApp privacy policy is a case in point to say we started by dealing with it, maybe unofficially, and but we decided that we have to start the process afresh and deal with the privacy policy of WhatsApp legally, which is what we are doing. And it's going to be interesting to see how that unfolds once we hear from them. But it's something that we think we have to do as South Africans to ensure that the privacy of us people down the most southern tip of the world, our privacy matters as much as that of people in other parts of the country. But I think the other exciting, not exciting, maybe interesting investigation to look out for is the one that I spoke about, where we're going to have public hearings from the 2nd to the 4th of August, because that's where we're going to get access to information and copyright law so far as it relates to payment of royalties. I think this is something as well that, depending on the outcome of the investigation, can have a positive impact on that industry. But I think that's how far we take it. We continue to work. We started with only us, 5 members of staff. In 2019, there was a lockdown. So before COVID, we had 20 members of staff. And we came back after the lockdown, and we have 90 members of staff, 90, so we're not doing too badly. But please remain our ears and our eyes, and also our ambassadors to preach protection of personal information and access to information. Thanks.
Thank you, Chairperson. Friends, colleagues, brothers and sisters, I don't want to stand in the way, your way to breakfast, so I'll be very brief with my final remarks of Thanksgiving. I just want to end off by quoting a commissioner from one of the Chapter 9 institutions who used to end each meeting by saying, to all those that support us, those that wish us well, those that want us to succeed, we'd like to say thank you, we appreciate you, we love you. Please, as you drive back home or to the office, drive carefully, because we want to see you once more. To those that want us to fail, who am I to tell you how to drive?